Hello everybody and welcome back to Lysenko channel on YouTube. Lysenko is a federally registered trademark in the United States of America in Class 45 Legal Services. I have just finished a brand new article. It's titled Intellectual Property Protection for a Software in the United States of America. Accordingly, this video is about this subject matter, and I would like to cover the major points of this new article. This article covers a few major possible protectable areas in relation to a software. In particular, I cover a possibility of a patent protection, a possibility of a copyright protection, a possibility of a trademark protection for software, as well as a trade secret protection. So let's talk about software, what it is, right? How we use it. A software is a unique specific language or a way of communication between humans and a computer or a machine. It allows humans to use a specific algorithms, formulas, programming language to interact with a computer in a particular fashion, right? So as a result, a software engineer learns a particular programming language, uses that to create a specific way to communicate with a machine, so that later on either that computer engineer or other people can use that way of interaction with a computer. So this is pretty much what a software is. However, it's not that easy to categorize a software into a particular type of intellectual property as far as intellectual property protection. And the reason for that is because of a unique hybrid nature of a software. As a matter of fact, US Congress spent a substantial amount of time trying to figure out under what category of intellectual property to place a software. Ultimately, it was decided that it's likely to be copyrightable for the most part, based on how it is created and how it exists and how you can basically track down what it's based on, right? So, however, here's the a more general overview. Software is a unique creature, and it combines a different elements. It has a particular end goal. It has a particular purpose. It has a particular path to accomplish the desired outcome. It has a specific source code, and that source code is being translated through the machine code into a consumer-friendly interface, so that we all can see something that we can process and understand on a monitor of our computer, just like you can see me talking on the screen. It requires a number of different processes to engage, to record it, to save it, and then transform it in a way that we all can see just a nice video of a speaker trying to convey a particular idea. However, because of that unique hybrid nature of a software and incorporation of different aspects of features, a software could be a subject to different intellectual property protections. And this is what my article is about. Right. First of all, a patent protection. Right. So in general, U.S. patent law protects inventions. To qualify, it shall be novel, useful, and non-obvious. This is a general requirement for a patentable invention. At the same time, in addition to that, an invention should satisfy it should be patentable in the eyes of patent law. It should fall into a patentable category, right? So patent law does not protect an abstract idea, laws of nature, or a natural phenomenon, right? So there is an exception. It's not just as simple as novel, useful, and non-obvious. There is also some additional provision, right? It shall not be a well-known principle or abstract idea. Therefore, when we try to translate it in relation to a software, right? So if all we have is a generally known idea, abstract idea, or a mathematical formula, and all we do is we add a particular computer algorithm to that, so that is unlikely to be enough to create a patentable invention in the eyes of a patent law, right? So if a particular general abstract idea or a generally known formula is used in combination with a mathematical formula or a software that supports that formula. However, there's something else to it, something else that make it creative and unique, something additional innovative touch. That's where we could possibly have a patentable invention. However, if it also satisfies those three requirements of being novel, useful, and non-obvious. So from that standpoint, it's not very easy bar to overcome, right? Is it possible? Yes, it is. It's a complex process, and there's no guarantee at the end, but it is possible. And one of the example of one of the recent patents that I came across was a software that provides means to share and purchase digital music using unique near-field communication methods and chips. So that was issued a patent protection. It is a software. It is a subject to copyright protection, but it is also a subject to patent protection at the same time. So the difference is that, in patent protection, once it is granted, it's difficult to secure, but once it is granted, it gives the holder of a patent usually 20 years of exclusive rights to that inventive idea itself, right? It doesn't matter how a third party can come up with it or arrive to the same end goal. A patent gives its holder a unique exclusive right to that inventive portion of idea that satisfies the patent requirements. Therefore, the value for a software could be is that now if somebody has exclusive patent to a particular inventive idea, and now another third party can unlikely to be able to come up with an alternative independent source code to accomplish the same end result. That's the difference and benefit of a potential patent protection. However, it's very difficult to satisfy the requirements, and there's no guarantee of success. It's a complex process, but that's the patent part of it, right? So then we consider the next possible protection is a copyright, right? So copyright protection for a software. U.S. copyright law protects original creative work of authorship fixed in any tangible form of expression. So the Copyright Act identifies a computer program as a set of statements or instructions to be used directly or indirectly in a computer in order to bring about a particular result. So based on that definition of a software in the Copyright Act, software is a part of a literary work because it is created and saved in a form of particular language, right? It is a programming language, however, it is a language, and therefore there's a way to express it. Therefore, it is copyrightable. However, what is important to understand is that because software is a unique creature and part of it may be copyrightable, the other part of it with additional features such as a particular functionality that could be a subject to patent protection is not protected by a copyright. And that's what's important to understand. So now a particular portion of software could be subject to a copyright, and there are ways to first of all, once it's created as any other copyright, its creator is considered to be its author and owner, right? So there's no requirement to register a copyright. However, it's highly advised to register any form of intellectual property you may have, because that's going to be your proof of your ownership of intellectual property and the priority date and your good faith in creating and owning that property. Good faith is very important. Anybody asserts a violation, you open your drawer, you pull out a certificate of registration, and you say, hey, give me a break, and I have a clear evidence that I own this intellectual property, and just do not start the fight that you're gonna lose. It's much easier to protect your intellectual property when you have a registration. Otherwise, it's your word against somebody else's word, and again, you may well be able to win that fight, but it would be more complicated, and it would involve more actions in order to defend yourself. So that's a copyright, right? So we have possibility of a patent protection, we have a possibility of copyright protection. How about trademark? What's the difference? How is it possible to protect a software or related aspects of a software as a trademark? Yes, it could be possible. Trademark is a source identifier of a particular product or a particular services. So if there's a particular term that is used as a source, like a company that sells a software, if it's a source of the product, then that term could be functioning as a trademark. For example, a computer software in class 9, or maybe there's services in that related field, maybe a computer software development in class 42, right? So now we have services. So if we have a term that represents the source of goods or services, now we may be able to have a legitimate trademark. What else? There was an interesting case resolved in a trademark trial and appeal board in 2021. A company tried to register a particular design as a trademark for a computer game, and it was refused trademark registration because that design was determined to be a computer game character, like a part of a computer game, but it did not function as a source identifier for that computer game. This is a good example how it works. A particular design or a logo could function as a trademark, but it has to do the job of a trademark, a source identifier, not something different, right? So at the same time, a well-designed, a creative character, let's say a computer game character, could easily be copyrightable if it is unique and creative, and it fits in any tangible form of expression, and it satisfies the minimum bar of creativity, which is not that high. It could be copyrightable. It could be easily copyrightable and registered. A certificate of registration is a nice thing to have for a unique and creative design. At the same time, a particular design that is simple in nature could easily function as a trademark if it's available, right? However, it may not be creative enough to satisfy the bar of creativity for a copyright. So under certain circumstances, one design can function as a trademark, but not have enough creativity to be copyrightable item. In other circumstances, a design could function as both a legitimate trademark and a copyright at the same time. Under slightly different circumstances, a design may be determined to be a part of a computer game, and like a character, right? It's possible that that would not be able to function as a trademark. Here, what's important to understand is that sometimes a proper alteration of a design could help. Not only alteration, but also the way a particular design is used, displayed, and advertised could affect consumers' perception and requirements of trademark law, and could help to satisfy both copyright and trademark law requirements in order to be protectable under the both intellectual property concepts. So that's the we covered 3 parts so far: patent protection, copyright protection, trademark protection. I have additional 4th part as part of my new article, and that is a trade secret protection. So trade secret protection is also a very interesting concept. First of all, trade secret originates from two different areas of the law. One is property law, and then going forward, intellectual property law. I own something, and therefore you may not use it because it belongs to me, right? And the second part that the trade secrets come from, originate, is the law of torts. They were originally existed under the restatement. However, then they develop into a separate area of the law. But the part of the tort is that some kind of wrongdoing, right? You do something wrong to me, it may be negligent or reckless in relation to something that I have, and therefore I may have a cause of action against you. So it's an interesting concept. It's an interesting concept. And generally speaking, trade secret may protect a wide range of information. The general requirement for a trade secret is that information should be able to function as a secret. That's number one. Number two, reasonable steps must be taken to secure that the secrecy of that information. And number three, improper means of acquiring that trade secret by a third party. So now there's some specific concepts that's important to understand. Trade secret does not give its owner exclusive right like a patent does. Trade secret does not protect against reverse engineering or independent discovery by somebody with good faith. There are limitations with trade secrets. However, at the same time, trade secret can protect a much wider range of information that could never be protectable by a patent, simply because there's no requirement for it to be necessarily novel, useful, non-obvious, etc., etc. As a matter of fact, the law to the requirement to satisfy trade secret protection is lower, and sometimes even a well-known concept or a combination of well-known concept could be protected by a trade secret if its entirety, the combination, or let's say the way this concept are used together is still non-obvious, and there is some form of creativity which kept in secret. So I think that to really understand the concept of intellectual property protection for a software, it's a good idea to consider its unique hybrid nature and review possibility of patent protection, copyright protection, trademark protection, and trade secret protection. This is how one can really understand what it is and how it could be protected. This is my brand new article, Intellectual Property Protection for a Software in the United States of America. It's going to be published on my website, lysenkolaw.com. I invite everybody to take a look, check it out, and I thank you for opportunity to be able to speak, to be able to convey this new article to anybody who is interested. Thank you very much, and I hope to see you soon with a new article or a new announcement. Bye.